Hello everyone, I'm Claudia Nadh, Assistant Professor, Soundarya College of Law. Today we are going to be dealing with a significant topic, PIL, Public Interest Litigation. In India, the concept of PIL started off with a habeas corpus petition when a letter written by an aggrieved party was considered. We also know that Article 32 of the Constitution and 26 of the Constitution empowers the High Court and the Supreme Court to take up PILs. And right now, from the habeas corpus petitions, it has evolved into a lot of other streams and has become the voice for the voiceless. It right now deals with the women issue, on bride burning, harassment, so on and so forth, children's issue, workmen compensation issues, anything to do with the socially backward and vulnerable people. Like I said earlier, it has become the voice for the voiceless, wherein even a third party, a person who is aggrieved, can take up the cause for someone else. So today's discussion in detail will be the relaxation of locus standi to the public interest litigation. So let's take a look at the presentation.
Locus standi relaxation in public interest litigation. The synopsis for today's discussion on PIL is going to be the basic understanding of what locus standi is. We will also analyze the technical definition of public interest litigation because none of the statutes have actually defined what a PIL is. We will also look at the nature of PIL. We will look at a couple of case laws on how the locus standi was relaxed, and we will also discuss the drawbacks of PIL in brief, and then we would conclude. So, the term locus standi is synonym to the word standing. We all know that locus standi is essential for an applicant to invoke the jurisdiction of the court. Take, for example, if I commit a breach of contract with you, then a third party would not normally have the locus standi to sue me because the third party is always a third party and is not part of a contract. And if an applicant has no locus standi, then his or her petition will be dismissed or disregarded without even looking at the merits of the case. But our Indian constitution has a healthy or a positive attitude towards PIL and have taken a view that the aggrieved party can approach the court via a writ even if the person's personal right is not in question. So the third party can voice out somebody else's pain. But what is very important is that the nature of issue that this person is addressing should be of public interest. So we also need to understand what exactly is public interest. For that, we'll have to go through the technical definition. And like I said earlier, PIL is not defined in any statute, it is just a practice. But we'll have to go through the technical definition to find out what is public interest and what is litigation, and then sum it up. Public interest, an expression which indicates something in which the general public or the community at large has some pecuniary interest or some interest by which their legal rights or liabilities are affected. So, this is a very broad meaning and has widened the scope of what public interest means. Here, there is no scope for individualism, it is always having the scope of public, of people at large. And the courts have time and again stated that public interest is nothing but the intent of public at large. So let's take a look at what is litigation. On the other hand, it means a legal action including all legal proceedings initiated in a court of law with the purpose of enforcing a right or seeking a remedy. So now we know the technical definition of public interest, we know the technical definition of litigation. So, lexically, the expression public interest litigation will denote a legal action initiated in a court of law for the enforcement of public interest where the rights of an individual or a group has been affected. Let's now take a look at the nature of public interest litigation. So, we have identified these pointers that are there on the presentation to be the nature of PIL. It has a remedial nature, it has a representative standing, it has citizen standing, non adversarial litigation, crucial aspects, epistolary jurisdiction, relaxation of strict rule of locus standi. So, this is actually what PIL is. Let's analyze it one by one. Remedial in nature. The remedial nature of public interest litigation currently departs from the traditional view. The traditional view of locus standi rules are widened now. Now, a third party can pitch in and take up another person's cause. And it has indirectly uh, led to part 4 of the constitution into part 3. That means it has incorporated part 4 of the constitution into part 3, thus giving part 4 more validity. That is the remedial nature of public interest litigation. Now, what is this representative standing? It is an approach where the third party can file a habeas corpus petition, making the Indian concept of public interest litigation much broader. Citizen standing. This nature of PIL has made it possible for us to expand from the protector of individual rights to the guardian of rule of law. Now, rule of law is a very important tool which the courts use to maintain democracy. So, citizen standing from an individual protector, it is moving to something which is more meaningful, becoming the guardian of rule of law. Next point is non adversarial litigation. So, there are two aspects to this: collaborative litigation and investigative litigation. Collaborative litigation is, as the name suggests, the claimant, the court, the government or public official will work together and they will try to fulfill the constitutional obligation. And in this regard, the court will normally perform or assume three functions. So, the first function which the court will assume is the function of an ombudsman. It will take up the role of an ombudsman. And when the court receives a citizen's complaint, it will bring the most important ones to the attention of the government official who is responsible for the same. And the second assumption is that the court will act as a forum and it will discuss the public issues and provide emergency relief via interim orders. And thirdly, that's the last point, the court will act as a mediator and will come up with a viable possible compromise. So, what we dealt with now is a collaborative litigation wherein everybody will come together to solve a social issue or a cause. Now, what is investigative litigation? When the courts will work and rely on the reports of registrar or the district magistrate or newspaper, comments of experts, then it will be termed as an investigative litigation. So, moving on to the next nature or feature of public interest litigation is crucial aspects. In certain scenarios, the courts have rejected and refused to withdraw public interest litigation and even offered guidelines. So, in rural litigation and entitlement Kendra versus state of Uttar Pradesh, the court refused to withdraw PIL itself and they ordered compensation for all. Okay, so even when uh, you know people filed a PIL and later they were like, no, we will take it back, we'll withdraw it back, the court said no. They took up this cause and ensured that compensation was also paid to the people who actually suffered. And in order to curtail custodial violence, in Sheila Barse's case, very famous case, they have issued guidelines, the court has issued guidelines to broaden the meaning of right to live with human dignity. And what is this epistolary jurisdiction? It means acting on letter written by on behalf of the oppressed people. This strategy of epistolary jurisdiction is adopted by the Supreme Court so that they are able to facilitate access of justice to all. So, even if you write a letter, it will be considered as a public interest litigation. The last point or discussion under nature of PIL is relaxation of strict rule of locus standi. So we have already dealt with what exactly is locus standi, and of course, we will have to deepen our understanding. For that, we will have to go through the illustrative case laws on relaxation of locus standi. Let's take a look at these case laws one by one in detail. The first case is SP Gupta versus Union of India. We know that this case is also called as a judge's transfer case. The Supreme Court allowed a group of lawyers to file a writ petition challenging the constitutional validity of a circular of the law minister relating to transfer and non confirmation of High Court judges. And in People's Union for Democratic Rights versus Union of India, the petitioner, who was uh, who was an NGO, he was a very public spirited NGO, and he was allowed to file a writ petition on behalf of persons belonging to socially and economically weaker sections employed in construction work for the Asian Games in 1982. Vaishaka versus state of Rajasthan. This is also a very famous case. So, in this case, a writ petition was filed by some social activists and non-governmental organizations, and the Supreme Court laid down some important guidelines in at preventing harassment of working women. So. They came up with some guidelines to provide a safe working environment for women in India. DK Basu versus State of West Bengal. Here, the Supreme Court expressed its shock at the number of deaths which occurred in lockups and police custody, and they laid down 11 guidelines as preventive measures to be followed in all cases of arrest and detention. And in this case, there was a letter which was addressed to the Chief Justice of India. We are talking about epistolary jurisdiction. So there was a letter which is addressed to the Chief Justice of India, drawing his attention to certain news items appearing in Indian Express and the Telegraph, and was converted into public interest litigation. In another case of DS Nakra versus Union of India, a group of public like-minded people, citizens, they had formed themselves into a registered cooperative society, and they were allowed to file a writ petition seeking a redress for old and retired pensioners who did not have the financial means to approach the court to actually redress the issue. And yet another case is state of HP versus parent. In this case, the guardian of a student of a medical college was allowed to file a petition drawing the court's attention to inhuman acts of ragging of junior students by their seniors. And the last case which we have quoted is DC Wadhwa versus State of Bihar. In this case, a professor of political science was allowed to file a writ petition complaining that the practice of issuing ordinances on a large scale would amount to a fraud on the Constitution of India. So we see the various instances of or scenarios wherein the third party, a person who is not at all involved in this issue, has taken up the cause for someone else and the courts have encouraged it. So, thus we know that there are many scenarios wherein even a political science professor or in case of a student, a parent can represent. Um, if for these retired people, it's a group of people who are not, they're not even retired, they're just they're public-minded citizens. They formed and registered a cooperative society and took up the cause of pensioners who did not have proper financial means to approach the court. So these are all various scenarios of different people coming together, and the courts have actually relaxed the locus standi to uphold the rule of law, like we discussed earlier. Now, are there any drawbacks to public interest litigation? Personally, I feel that public interest litigation has given a chance for many people to be heard, but of course, it comes with drawbacks like any other concept or anything which is developing. Um, Competing rights is one issue. Whenever a public interest litigation issue comes up and is discussed, there might be an issue of a competing right. Example, when the court orders for a polluting unit or an industry or a factory to be closed, it orders for a closure, then it deprives the workmen and their families of their livelihood. So you look into the environment and then you will lose out on the labor part of it, the workman part of it. So they're losing their livelihood when you ask them to close a polluting unit. So that competing rights issue is always there with the public interest litigation. Another issue is of inordinate delays in disposal of PIL. So right now there are a lot of pending PILs before the court, and which is there for many years, and it is highly criticized that many leading cases which have become the of academic value. It's actually PIL is regarded as a mere academic value concept, but in reality, it is not so, is one of the criticisms. Because there is high delay in disposal of some public interest litigations. In conclusion, we can say that PIL is now working as an important instrument of social change, no doubt about it. And in the words of Justice Krishna Iyer, the judicial activism gets its highest bonus when its orders wipe some tears from some eyes. Unquote. Thank you.